At issue, the controversial legal defense that allows rape accused to claim they believed the victim had consented, even if that belief was unreasonable. This following the acquittal of a rape accused who claimed not to have heard his victim say no. The High Court later ruled that this defense was unconstitutional, saying it unfairly shifts the burden onto victims. At the heart of the challenge is a controversial legal defense that an accused can claim they believed there was consent even if that belief was unreasonable. Advocate Nasreen Rajab Batlenda SC has urged the Apex Court judges to rethink how intent is assessed in sexual violence cases.
The notion that unless a woman screams or fights or tries to run away, that she must be consenting to the act. Or that, as this court has referred to, it's always the monster who rapes, not the father, not the brother, not the uncle. That's another myth. Or if that you consent to one act, that you're effectively consenting to a whole series of acts. And while the law has tried to keep up with these things, and certainly the act has been amended in an attempt to deal with, societal norms are much harder to change, we know that. And these feed sexual violence. And when they find their way into the subjective intention and the mindset of a rapist, in the context of this statute as it stands, it makes it virtually impossible for the state to prove beyond a reasonable doubt.
The timeline of the case: in 2024, the Pretoria High Court acquitted a man accused of rape after he claimed that he believed the victim had consented despite her asking him to stop. The court accepted his subjective belief as a valid defense. The same court later ruled that the defense was unconstitutional, stating it unfairly burdens the victims and undermines their rights. In 2025, the case was escalated to the Constitutional Court by the Embrace Project for review.
That the accused took all reasonable steps to ensure that where a person was 18 years older, the representation did not depict that person as being under the age of 18 years. The way in which we've tried to craft our relief is to say that we won't tamper with the text of the offense, but that where an accused tries to raise a defense of consent, because there may well be other defenses, but where he tries to raise a defense of consent and consent becomes the issue, then he needs to show how he determined that there was consent. And we say that he must show that there were reasonable steps taken to show that consent.
The court will consider whether the current legal framework violates constitutional protections. If the Constitutional Court confirms the High Court's ruling, then Parliament will be required to amend the law. And the defense of subjective belief in consent could be scrapped, which will force rape accused to ensure they prove beyond reasonable doubt that there was consent before the deed was done.
Responses to sexual violence take various forms, and I do want to emphasize that none is incorrect. However, it is worth noting that the peritraumatic responses of freezing, tonic immobility, and collapsed immobility are all passive responses. And more than that, they are likely to prevent a survivor from being able to communicate their lack of consent.
In a country where rape conviction cases sit at a shocking 10%, legal experts say this case could reshape how rape cases are prosecuted and potentially improve conviction rates. Judgment has been reserved in the matter. Offense Estimo, SABC News, Johannesburg.